Morning, everyone. My name is Kristen Mon, and I am the housing coordinator for the city of Tulsa. A little about myself, since this is my first time meeting many of you. As the housing coordinator, my role is focused on implementing the citywide housing strategy with a focus on preventing displacement and homelessness in our community. With COVID-19, we're focused on implementing strategies to prevent displacement while the moratorium is in place and also once it has been lifted. I would like to briefly tell you about one of the resources currently available to prevent displacement, the Early Settlement Mediation Program. It is a free program sponsored by Tulsa County and the Oklahoma Supreme Court. The Early Settlement Mediation Program provides free mediation to resolve disagreements between landlords and tenants. That includes difficulty paying rent and threats of eviction. For those who are unfamiliar, a mediation is a meeting with a neutral third party to help the tenant and the landlord resolve their disputes and come to an agreement that will benefit both of them. Both landlords and tenants are encouraged to apply to this free program as soon as the dispute develops. You do not have to wait to receive a notice or be threatened with eviction. You can apply by calling 918-596-7786. More information is also available on the Away Home for Tulsa website. That is awh4t.org/COVID-19-resources. For our presentation today, our goal is to provide information to tenants, landlords, and community partners on tenants' rights, especially during this unprecedented time. This is the beginning of what I hope will be an ongoing conversation. We are currently working on future presentations, including a presentation for landlords to provide answers about the CARES Act and help them to identify resources. I want to thank Legal Aid Services of Oklahoma, the Tulsa Health Department, and Homebase for sharing their expertise with us. As a brief overview of how today's presentation will go, the first presenter is Eric Hollett of Legal Aid Services of Oklahoma. He will be explaining the eviction moratorium and tenants' legal rights. Then Kendra Wise of the Tulsa Health Department will explain a tenant's right to a habitable premises and how complaints are being addressed at this time. Then Alyssa Weber of Homebase will explain the federal landscape as it relates to tenants' rights. After each presentation, there will be an opportunity for questions. To ask a question, please use the chat feature in Zoom. Everyone is currently muted and the cameras are off. We ask that you keep your mics muted and use the chat function to ask questions. Thank you everyone for attending today, and I'll turn it over to Eric.
Good morning, and thank you. And so I'm going to attempt to actually share my screen and do a PowerPoint. I'm sorry I don't have a video of me. My technology at home is actually a stone tablet. So I don't have the ability to put on my face, and that's okay because I'm still wearing what I woke up in. So for those of you who don't know me, my name is Eric Hallett. I'm a lawyer in Oklahoma, and I am an attorney at Legal Aid Services of Oklahoma. I've been there a long time, practicing law 16 years now. At Legal Aid, we provide free legal services for civil legal matters to people who cannot afford a lawyer. And generally, that includes people who are under 200% of the federal poverty guidelines. We have one attorney for every 10,000 Oklahomans that qualify, or at least that was the case on March 1st. Now I have a feeling that we have a lot more people that qualify for legal aid. So we shall see. I wanted to start by saying that I give a lot of these presentations, and I give them with Kendra all the time from the health department. And, you know, one thing I hear a lot is, you know, this seems to be too tenant focused. I need to know more about landlord law. And the truth is, I am a tenant rights lawyer. I do help run an eviction prevention program in Tulsa County. Tulsa has the 11th highest eviction rate in the nation among large cities. But I also do complex civil litigation for housing discrimination, and I work all over the state with advocates to help people understand landlord-tenant laws. And so I am a tenant rights lawyer, and but I don't want landlords to feel like that means I'm not being balanced in my perspective here, because I want to present to you the law as it is. But what I find is that a lot of landlords are actually surprised that tenants have rights. So it's not so much that I'm doing a tenant focus, it's just you're learning new information. Okay, so today I want to talk a little bit about the law and what I said to Kristen the other day was, the history of the law, and suddenly I found myself realizing that history means the last 3 weeks. So what has happened in Oklahoma, what it means for landlord-tenant relationships. I also want to talk a little bit about what is actually happening on the ground, and for service providers and tenants, the essential things that you need to know to help tenants through this period of time. And that includes a basic understanding of eviction, the problems that we're about to face, and some consequences. I'm going to try to keep it light, although, sometimes it does feel a little dark. And then lastly, I want to talk about where to go for legal help. And just to put it out there from the very beginning for you people who are working with tenants or for tenants, there is a lot of financial help on the way. Those lists are growing and changing. There's a bunch of federal dollars that will be flowing to the state that will be distributed among organizations that do rent catch-up. And so stay tuned to more announcements about where tenants can go to help with rent assistance. So let's start a little bit with the law and what's going on in Oklahoma. On March 16th, if you can remember back, it was just
Hey,
before we all, yes?
I'm so sorry to interrupt. I know you had a PowerPoint. I just want to double check that you're able to share your screen because it's not up right now.
Okay, so let me see if I am share screen, share. Is it
Perfect. Thank you. Thank you
okay?
so much.
All right. Well, thank you now for making work. Okay. So let's talk a little bit about the law in Oklahoma. On March 15th, Governor Stitt declared an emergency. And the next morning, the Oklahoma Supreme Court issued an emergency order that was really unprecedented, and for lawyers a little bit frightening, because suddenly all proceedings were suspended for 30 days, and emergency matters are allowed to be brought. However, judges were given some discretion to determine, how to proceed in different meetings. Remote are encouraged, but people with symptoms or had any contact with someone who had traveled were prevented or blocked from going to the courthouse. And at that time, there was a lot of confusion about what all of this in county, the first thing that came out was an order that said, all proceedings that aren't emergencies are suspended except evictions. And then a lot of us people here on this call, the mayor's office, legal aid, the Tulsa County Bar Association, and other people put a lot of pressure on the courts. And I knew on the 16th, and Tulsa County had also suspended all evictions going forward. So that's what's happening on March 16th. By the 27th, the Supreme Court had actually strengthened its rules and kind of took away the discretion from judges and said, you know what, we are not having any hearings until after May 15th. The courthouses were closed, and all filings are required to be done through email or by mail, which presents a real barrier to filing anything with the court unless you happen to know how these channels work. A lot of the counties updated their local orders at that point. And for me as a lawyer, where my worldview is centered around the idea of, the courts being the place where we settle our disputes, for me, this is very unsettling because suddenly we don't have a place to settle disputes because the courts are closed. So it's frustrating for landlords and tenants because they need a place to, deal with their disputes. what ultimately happened was that we had 77 counties in Oklahoma with 77 different procedures. Like I said, Tulsa County suspended hearings immediately, and that's been extended through May 15th for all evictions. But other counties, that has not been the case. You can go on oscn.net and look at the individual counties and what their orders are for that county. During this period of March 16th to March 27th, we had at least 11 counties continuing to hold eviction hearings, even though people were prevented from going to the courthouse. So we have a real due process concern that evictions are happening and tenants don't have access to defend themselves. We also have a concern that, you know, at this point, the governor and local leaders, health departments, the president of the United States are all saying, stay in your home. Don't go out unless it's absolutely essential. And so that court proceedings were continuing is a little frightening. If any service providers or tenants were affected during this period, if they were evicted without an opportunity to go to court, they should certainly speak to a lawyer as soon as possible. We might not be able to do a whole lot today, but eventually courts will be reopened and you'll have a very short window to get any relief. So as of right now, 3 counties are still holding evictions, and as of this week, judges in Muskogee, Cleveland, and Garfield counties have been evicting tenants. There has been getting some national and local media attention, and a lot of things are being done to try to stop that from moving forward. So the big question now is, well, if court is suspended, do I have to pay rent? Does that mean rent is forgiven? I cannot be evicted. Well, it is true. Tenants cannot be judicially evicted at this point because the court processes are suspended. But that doesn't change the fact that mortgage payments are still due for homeowners and for apartment owners. And rent is still due from tenants. There is no free housing. So yes, rent is due. Your landlord cannot evict you. That doesn't mean that at the end of this, you won't be evicted. The fact is, evictions are still being filed. That hasn't stopped. And we'll look at that a little bit in a minute. But the important part to remember is that rent will still be owed as of right now. And then the next question is, before we really get into kind of these processes, is what about inspections and repairs? I'm hearing from people that they are afraid to let the landlord into their unit for a routine inspection because they are trying to, you know, self-distance or social distance, and they're in isolation or they're sick or they're high risk. And so at any time, regardless of whether or not we are in a pandemic, landlords are required to give tenants 24-hour notice of their intent to enter a unit. And that's in writing. The landlord needs to give them a written notice saying, I'm coming into your unit. And at all times, the tenant has the right to deny entry into the unit if it's reasonable. Well, right now, quarantine and being a high-risk category, those are good reasons to deny entry. And as a practical matter, routine inspections of units really need to be canceled out of an abundance of caution, not just for the safety of the tenant, but for the safety of the person doing the inspection. What's essential here is that communication needs to be there. The tenant and the landlord need to not be afraid of each other, and they need to be respectful of each other. Communication and coordination are going to be very important, especially for completing, you know, emergency repairs. So you might not want a landlord to come into your unit because of sickness or fear. However, if you need emergency repairs done, you're going to have to coordinate that. Again, communication is essential for tenants and landlords at this point. So what I said earlier was that you can't be evicted, but evictions are still being filed. And Oklahoma Policy Institute and Ryan Gensler at Open Justice Oklahoma have put together a great website that they released yesterday on where evictions are happening in Oklahoma, who's filing them. And as of yesterday, there were more than 1,100 evictions filed in Oklahoma since March 16th. And even though those can't move forward, they're still filed and they're still being served on tenants. Tulsa, of course, leads the pack with 527 evictions filed as of yesterday. But Oklahoma County is, behind them. And these other counties on the screen are the highest filing counties at this time. So why do evictions happen? Honestly, in Oklahoma, evictions happen for no reason. There doesn't have to be a reason. If your lease ends or you're on a month-to-month tenancy, the landlord could just say, I don't want you here anymore. And so evictions happen for no reason. But most evictions happen on paper because money is owed to the landlord. So all evictions that end up in court, almost all of them are for money. Now, a lot of times money isn't the real underlying reason for an eviction. It's just the fastest way to get to court. So if a tenant's been behind, and maybe they pay every month, but they've been behind for a while, it can easily, they can be evicted quickly on a 5 days notice. Really, people get evicted for other reasons, breaking the rules, damaging the landlord's property, doing things that are illegal. Those are all reasons why landlords want tenants out. Those are reasons why people make bad neighbors. And so that could be an underlying reason for an eviction, even if rent is the reason that's filed in court. Discrimination is something we have to be considering right now. It's something that happens a lot, where one family can break rules, but another family that looks different from that first family is not allowed to break rules. There could be, a difference in treatment. And right now we're worried about, discrimination because of illness or perceived illness, or because of national origin. Evictions also happen for retaliation. A lot of evictions happen because I have a dispute with a landlord. I want my toilet cleaned out or cleared out, and the landlord won't do it. So I call the health department because I have a backup sewer. And then the landlord decides to call in that rent that's due, even though, they may have a long history of letting a little bit of rent be owed. It's when the tenant decided to complain that the landlord decides to enforce those rent rules. But ultimately, almost all evictions, regardless of the reason, come down to miscommunication. And that is essential for service providers and tenants to be aware of. We have somewhat of an imbalance of power between landlords and tenants, and that exacerbates communication problems. Consider also that right now, a lot of people in Oklahoma are finding themselves in poverty for the first time. Poverty is very stressful. 45,000 Oklahomans filed for unemployment last week. Poverty is not only stressful, but eviction is stressful. Not being able to provide for your family is stressful. And when you also consider perspective that they're not getting the revenue they need to support their family and to pay for their assets, they're also being stressed. They're being stressed as much as the tenant is, and that is really going to make communication problems even worse. So the most important function that we can provide as lawyers or as advocates for tenants is to help bridge that communication gap. So how can we help tenants facing eviction? So some effective strategies are education, learning about what eviction is and what eviction is not, learning about what the situation is and helping tenants understand their rights. Communication, again, this is the #1 complaint from landlords. My tenant didn't communicate with me. And it's probably the same for tenants that feel like the landlord, has an imbalance of power and isn't communicating with me either. And like I said, when people get stressed or their feelings get involved, then suddenly those communications really break down. So we can really provide, again, that bridge there in communication. And then lastly, we can help tenants by helping them prepare. They need to be ready for what's going to happen if this becomes a court process or if they do get evicted. Tenants need to prepare to be ready for the court process, to participate in the process, and then they have to prepare for leaving their unit if they are judicially evicted. And if you take nothing from me today, if you're nothing from this at all, if all of this is just a waste of your time, take this one piece. Everything between landlord and tenant needs to be in writing. So all of the tenant's rights that they have under the Landlord-Tenant Act, none of them are triggered unless a written request is made to the landlord. But writings also help us keep a record of what happened. If you end up at court in the future and all you can do is testify about what transpired, between you and the landlord, or between the landlord and the tenant, remembering dates, remembering exact agreements, that becomes very hard to do, especially when you're under oath and you have a scary judge up on a bench wearing a black robe, looking down on you, and you are not going to remember things. That's just reality. Plus, writings just make better evidence. Landlord, or the testimony from a tenant or a landlord might be lost. The judge maybe didn't hear something or didn't understand what that person was saying, but if they can see it in writing in front of them, that tells them exactly what's going on. But then also, and finally, written agreements are just easier to enforce. If the landlord and the tenant agree, the tenant's going to give a portion of stimulus money, say, on a certain date, and then the landlord's going to take this other action. If they don't write it down, by the time it gets to court in 2 months, the terms of that agreement are going to come out very different from each side. And the judge is going to say, well, you have a written lease. Any other agreement that's not in writing isn't enforceable. So it's important that all things between landlords and tenant are in writing. And so when even I call a landlord to be that bridge and a communication gap, I like to follow that up with a letter that says, this is what we talked about, or this is what we agreed to. When it comes to writings, there's no restriction that you not do it in text. However, text messaging is terrible because what I found is that people lose their phones or they break their phones, and those phones no longer produce those text messages. Furthermore, text messages are very hard to print. And if you're a judge who hears 20,000 cases per year, you do not want to touch 20,000 nasty cell phones, especially now. So no judge in our courthouse or that I've ever met will agree to take your phone and look at what it, pictures or text messages. You have to print those things. So emails are much easier to print, as are, making copies of things that you actually wrote out the old-fashioned way. All right. So let's get into like the actual eviction process. There are 2 ways to do things. There's a lawful eviction, and then there's an illegal eviction. And regardless of what the law says of what we can and can't do right now, lockouts have always been illegal and will always continue to be illegal. Only the court can order that a tenant be removed from a unit. Only the court can do that. And that requires going through the formal court process and making it all the way to the end. We are seeing not as many lockouts as I expected right now. What I'm seeing a lot of is utility terminations. Utility terminations are always illegal. So what I know right now is that the utility companies are not terminating utilities. And what I hear from landlords is things like, well, utilities are included, however, they're not paying rent, therefore I can't pay my utilities, therefore I'm going to get cut off. Well, that's not true right now. Right now, no one is getting cut off on their utilities. However, I do have landlords all over the state right now that are doing just that, that are terminating tenant utilities and trying to force tenants out. I have a family of a couple with young children in Woodward County right now that their landlord told me well. He told me that I couldn't afford the bill and the city turned it off. So I called the city and I said, is this true? And the city said, well, what's true is that he called us and said, we need to kick out my tenants. Will you cut off my utilities? And so I went and did it. That is creating a much worse situation than we currently have. If people need to shelter in place, they need to be able to do that in a way that's safe and sanitary. In Tulsa County, you'll hear Kendra talk about, you can call Kendra and or fill out an application online, and the Tulsa County Health Department can take care of that and really be useful in getting utilities restored. However, out in the rural areas, those health departments don't have the same ability to do those things. So the first person I called in Woodward County was their inspector, and he said, I don't have jurisdiction. And, you know, we're just making calls, doing everything we can, and today we have to talk to the judge because it's been 8 days for this family. If people are experiencing lockouts or utility terminations, this is when you absolutely need to take some legal action and contact a lawyer. So the actual legal eviction process has steps, and it always follows these steps. We have a written notice from the landlord to the tenant that tells them what the problem is. Maybe it's you didn't pay your rent, you owe rent, or you broke the rules. And after that written notice is given, time must pass because the tenant has an opportunity to correct the problem. Under the law, the tenant has a grace period to fix things. So for rent, they have 5 days. For a lease violation, they might have 10 days. And for other circumstances, they might have 30 days. And it really just kind of depends on the situation, how much time the tenant has to comply. If the tenant complies with the notice and the demand from the landlord, the process stops right there. If the tenant doesn't comply, that's when the court can become involved and the landlord can file an eviction action. It's called a forcible entry and detainer. That action must be served to the tenant. The tenant will receive a summons that tells them when their court date is. And in Tulsa County, it's usually either pink or gold, and it's a legal size piece of paper. It can be served personally on a tenant or someone in the home at least 15 years old, or it may be tacked to the door. But either way, they have to serve the tenant at least 3 days before a hearing so that the tenant knows when and where they are supposed to go to court. And then there'll be a hearing before a judge. At that point, the tenant has the right to be there and tell the judge their side of the story. If the judge decides to go forward with an eviction, the court will sign an order that will have the court stamp and the judge's signature that says the landlord gets possession. And then in Tulsa County, the next day, the court will be willing to sign an order to vacate. So there's 2 orders, one that grants the possession and a second order that orders the tenant to leave. And the tenant is given a 48-hour notice to leave. If the tenant doesn't leave within those 48 hours, then the lockout can occur. It should be done by a sheriff to keep things safe. Right now, the sheriffs aren't doing those, but it's also possible under certain circumstances for the landlord to do the posting. If they do that wrong, though, they could be liable to the tenant. So it's always best to try to use the sheriff for that. Any eviction that happens that doesn't follow these steps there's a problem, and you need to speak to an attorney. So before court processes begin, or even before to court, one, seek legal advice. So in Tulsa County, we have an entire team of lawyers that only do eviction prevention. So if you call legal aid will help you with your problem. The sooner we know about it, the more we can do about it. Because not only do you need advice about your situation, you also need to gather evidence. And this is really where service providers can be helpful in educating tenants gathering evidence. If it's a rent case, you're going to want an accounting to see what I've paid and what I owe. and what I've been charged. You would be surprised the charges that tenants incur. Just at the end of February, I had a tenant come to me. She was an eviction was being filed for just a couple $100. Her monthly rent was $600. But in the 12 months before this, she had paid $1,200 in fees to the landlord. So over a 1-year period, she had paid 14 months worth of rent. And here this landlord was trying to evict her for a couple $100. And, we were able to get that thrown out because this woman had essentially prepaid rent. So it's important to get those accountings and show the judge this is what is going on here. And it also gives a lot of leverage for negotiating, because before court processes begin, and as Kristen was mentioning, mediation is essential. Getting that communication with the landlord about where are we at and what can we do to fix this is going to help that tenant avoid an eviction filing and avoid being displaced from their home. If mediation is not successful, at least those efforts were you tried, and the lawyer will now have some more information to go forward and be able to better advise the tenant on what's going on. So the number one problem we have with eviction in Tulsa is that tenants don't participate in court processes. We have right now, in the first 3 months first 2 months of 2020, I calculated between 12 and 13% of all people who were sued for eviction actually showed up for court. So failing to participate in the process always equals eviction. Whereas participating, if you come to our eviction prevention program, or you meet us at the courthouse, or we get involved before the court proceeding, we can, even if we cannot find a way to stop the eviction, we can help with the soft landing. We can help give tenants plenty of time to move. We can help them craft payment arrangements and do other things that might prevent this eviction from showing up on their record. The real problem right now, and where we need advocates and tenants representatives helping, is that all the court dates are wrong right now. So 527 cases have been filed, but every single one of them were issued a court date, and those court dates may have been served on tenants, but those court dates are no longer valid. And tenants need to call the court and confirm court dates and current procedures, because in some counties, you're not, who knows when we're going to be allowed back into the courthouse. They may have some type of distancing procedure that they begin with. So getting understanding of when the court date is and what procedure to follow to engage in that process is essential. And then when it's time for court, the one thing tenants don't do is take any evidence with them. So many tenants say, well, I thought I could just ask the judge for a continuance today. And I say, well, today is your court date. So tenants need to take receipts, printed pictures of the unit if they want to talk about habitability. They need to take copies of notices, agreements, accountings, witnesses, whatever they have, they need to take with them on their court date, because you usually only get one court date. So I just wanted to talk real quickly about the problem I see for tenants. I talked about it a little bit about high fees, but right now when tenants are without income and not paying their rent, they're really at risk of amassing a lot of fees. So excess fees are not lawful anyway. In Oklahoma, there's a very narrow defined allowance for late fees. However, a lot of out-of-state owners of multifamily will use the eviction process to actually create revenue. And so they will sue tenants for these fees, and they will apply rent to fees first. And ultimately, late fees are not rent. And so tenants shouldn't be evicted for those fees. And it's definitely something that you can refer to me or another lawyer to look at those fees. And it's one area where if you're helping a tenant negotiate with a landlord for how they're going to be able to pay their rent, that you be aware, when a landlord says, well, we will negotiate, but we want a lot of money in fees, you might have to say, well, we're not going to be able to negotiate this because it's not fair that this family is not going to eat because you want these fees. And right now, landlords, while they may be afraid for their mortgages, the fact is, while there's no eviction filings, there's also no foreclosure filings. And so there's no late fees being imposed across the board. There's a lot of relief being given to owners. So there's really no excuse for them to have these fees unless they can show you in what way they've been damaged. Now, if it comes down to a small fee to get a deal done, maybe the tenant agrees to it. But be aware that high fees are not allowed ever. And you can always go to court and the court will strike down high late fees. So, and I also want to talk quickly about discrimination. Federal and state laws prohibit discrimination in housing for the 7 protected classes. State law also includes age, and the city of Tulsa includes sexual orientation and gender identity or expression, and ancestry. And then a new entry to the list of people that we cannot discriminate against and we should not discriminate against. Governor Stitt's executive order from, I believe, the 29th prohibits discrimination against frontline healthcare workers and their families. So if you have people experiencing discrimination, Legal Aid definitely wants to know about it. We are paid by HUD to enforce the fair housing laws. There's also Metro Fair Housing out of Oklahoma City that does the same work enforcing the fair housing laws. And we will certainly be able to help with that. But you can also help with that. You might not be able to file a lawsuit, but you can help with a HUD complaint. It is important that HUD be aware of what's going on in the world and prevent, and keep tallies of where discrimination is happening and what kind of discrimination. You can do that online. If you go to HUD.gov, you can fill out an online complaint and help a tenant start that process. It's a slow process, but it's an important process. The Oklahoma Attorney General also has an online form that you can download, print, and it has all the instructions you need for complaining about discrimination. So the future, it's a little frightening. We have 527 evictions that have been filed so far. We are currently closed through the 15th, the courts are. However, there is reason to believe that could easily be extended into June or farther. And during time, more evictions are to be filed. So with the evictions in Oklahoma, those have to be set within 5 to 10 days of their filing. And we currently have hundreds and hundreds and hundreds of tenants facing eviction the day that the courts open. So we're going to look at a flood of people at the courthouse. And the biggest problem being that all those courts have been changed. And there is no agreed process among lawyers or judges on how tenants are going to be informed of their new. In fact, I've been looking at court orders from around the state and trying to understand what's going on in different places. And in Creek County, for example, I saw a court minute that said, called the landlord, told them about their new court date, or it's going to tell the tenant. No, they're not. I've seen other courts say, this will be reset when the landlord asks it to be reset. I've seen a lot of courts just not know what they're going to do. So it may be that a lot of tenants are going to be evicted and never know it happened. So any tenant that has been served needs to be tracking their case and needs to be aware of when things are changing. And as soon as the courts come back up, call the court clerk and say, when is my court date? Because missing a court date could be catastrophic. The fact is, lawyers may be able to find, a due process or constitutional argument for why this tenant shouldn't have been evicted, but you're playing catch up at that point. At that point, the tenant may have already been put out of the unit, and we want that to not happen. So being aware of court dates before they happen is essential. But then there are other barriers that tenants face, and these are barriers that tenants always face, such as transportation or timing. So again, that happens in 5 to 10 days. That's a very short window to prepare for a hearing. But more than that, in Tulsa County, for example, hearings are always held at 2 o'clock. And so you have to be there from 1:30 to 4:30. And if you're a parent with children in school, that's not a very convenient time to be in court. Or if you have a job, very inconvenient. Which brings me to my next point, and that is employment. By the time that we get back into court, you're going to have families who want nothing more than to be able to provide for their families and have been out of work for 2 months or more. And they're going to be asked to choose between providing for their families or being evicted from their homes. And that's not a fair choice. So people are going to, go to work most likely because they can at least pay for the next place they're going. And then lastly, I see as a barrier the crowds that are going to be in the courthouse. Hundreds and hundreds of people facing displacement, people who are scared, and people who may or may not have health insurance, may or may not be sick. We're hearing right now about Hong Kong having a second wave of exposure now that they're allowed to go outside. I personally am thinking, do I want my team there at the courthouse? It's a scary thought that all these people are going to be in close quarters after we've been told to stay apart for a long time. So the consequences are that tenants lose everything. Eviction is a driver of poverty. And what happens when the court issues that 48-hour notice is this family has to find a new place, pay new deposits, pack their things, and move. And what I know as a homeowner, that when me and my spouse, who's also professional, we have no kids, it took us an entire month to move when we bought this house that we live in now, of weekends and evenings, because it's not easy. It's a lot of work. And if you also have to go to work, 48 hours is not practical. And so what happens is that people just lose everything. And telling tenants to gather their essential documents, identification, and et cetera, is important, because they need to have medications and things that are essential ready to go. But they will be left with something. They'll be left with debt. So the fees, the judgment, the costs, that attorney's fees and court costs, they're going to lose their deposit. And then right now, what happens when all the big multifamily is they give you a negative credit entry, and that prevents you finding other good housing. So tenants will be left in debt. And what I know right now, even though evictions are being not filed as frequently as they could be, debt cases are being filed like crazy. And so people are going to be facing not only eviction, but wage garnishments and other issues. And then lastly, I think what service providers can do is make sure that tenants ask for their deposits back. Even if they were evicted and they're not going to get their deposit back, it's essential to request it, because that will force the landlord to give you an accounting. And then if there are unlawful charges, we can attack that in small claims court. So to get legal help, 211 in Tulsa, great. You call them, they will connect you with resources, not just legal resources, but all kinds of resources. oklegalconnect.org will connect you with all the no-cost legal services in Oklahoma. Legalaidok.org goes to the legal aid website, and oklaw.org is a self-help website full of handy tools to get you through various legal issues. So thank you. This is a picture of Millie. Millie is has decided that the baby gate no longer presents a barrier to her. I'm thankful that I have a home, and that I'm not at risk, of losing mine. And I'm thankful that you came to listen today.
Thank you, Eric. So we have been getting a lot of questions, and I want to start out, the most questions we've gotten have been about late fees. So I want to start there to make sure that we cover them. Can a landlord charge you late fees if you can't pay rent or can only pay a portion of the rent? And is there any limit on how high those late fees can be?
Okay, so that's a great question, and it's such a hard one in Oklahoma because our law hasn't really been changed in a long time. And so the law says that a contract cannot include a penalty. And a lot of times we see late fees are put there because the landlord is going to teach you a lesson, or we'll use this as an opportunity for revenue. Late fees in Oklahoma can be charged if they are related to the cost on the landlord. And what we've seen in the couple of cases in front of the Oklahoma Supreme Court is that landlords have yet to actually show how they've been damaged just by receiving rent a day or two after the contract says it was due. I do hear landlords say, well, I had to take efforts to collect that rent by going and knocking on their door. And I say, well, you're a landlord and that is your only job. So I don't know how that makes someone damaged. If a landlord can show that they have been damaged, then they are entitled to a late fee that is related to that damage. Tenants are absolutely within their right to contest those fees and make the landlord prove that they were damaged in some way. Landlords do, there is no hard and fast rule on how much a late fee can be. However, in Tulsa County generally, if you contest a late fee, our judge has historically only allowed $25. And if you have months of late fees that you're trying to charge, the judge has historically allowed $25. And I think that's in part to satisfy the landlord and say, hey, shut up, here's some money. But also recognizes that landlords aren't really damaged by not receiving their rent on day one, as opposed to day two. Now, maybe not receiving their rent for a long period of time, maybe their damages do go up. But generally, you should challenge late fees is what it comes down to. And if they are $100 or more, which a lot of landlords are doing, that is just unlawful. I am currently suing landlords for late fee practices because they're using it as a way to generate revenue. And there was this really interesting case out of Texas a couple of years ago that showed this landlord had collected or had charged $625,000 in late fees over 4 years among 9 properties. And that's just an astronomical amount of money that they were not damaged in that way. So yes, the landlord can charge them. It needs to be reasonable, and it's definitely not going to be that high.
Okay. Are there any fees that are illegal for a landlord to charge? We've talked a lot about late fees, but is there anything that they can't charge for at all?
So the one thing that I see a lot is an eviction filing fee. The funny thing is that this fee, okay, so what happens is they will file an eviction. The eviction costs $58 to file. They will serve the eviction. The service costs $50. So overall, it costs $108 to file an eviction. And there are eviction companies that only live to file evictions and help landlords do that. And they tend to charge for their entire service around $120, $125. And that includes the filing fee and the service fee, and it includes hiring the lawyer and everything. Except that 2 things. One, the landlord then immediately adds a charge onto the tenant for $200 to $300 for a filing fee, which is wrong and it's fraud. And then when they get a judgment from the court, it already includes all those costs they had to pay. So then they end up billing this cost 3 times to the tenant. So those fees definitely not allowed. Other fees that are not allowed would be any fee that is not included in the lease. And right now, a lot of landlords are burying fees deep down on page 10. I will tell you, any landlords listening, juries are not impressed by those long leases. They'll say you owe rent plus, any other fees later on, and then you read through the lease, and then there's like a fee for a service connection, there's a fee for vermin extraction, which they're required to do anyway. There's just all these fees, and suddenly rent is 10% higher than you expected. So those could be problematic fees, but if they're included in the lease, there's a good chance they can charge them. And any damage you do to the property, the landlord could charge you for that as well.
Thank you. So one of these questions, I know a lot of people are dealing with an issue where their lease is ending and they don't have the ability to leave. So if a tenant's written lease ends on March 31st, but the landlord's letting them stay on the premises, and the written lease includes a provision for things like late fees, will that written provision apply even after the lease ends on March 31st?
So generally, when a lease expires on its own terms, both parties are released from it without notice and the tenant can move. If the tenant stays and the landlord accepts rent, their lease becomes a month-to-month arrangement. And that month-to-month arrangement should probably incorporate the terms of the written lease. Where the problem I see is that a lot of landlords include a month-to-month fee. Now that is a problem because that is no longer the same contract that you had before. That is a new contract, and the landlord cannot charge you new fees without giving you at least a 30-day notice that you're going to receive those fees. So your lease will just convert to a month-to-month. I would be wary of any fee that gets charged for being on month-to-month. I understand that the base rent of the unit may have changed, and it's important for the landlord to seek a new rental agreement to reflect the changes in the increase in rent. But it's also important that the tenant have some say in that as well. The landlord could easily give the tenant a notice that says your lease is expiring. If you want to renew, come and sign a new lease. If you want to go month to month, the base rent for this unit has changed and I would like to charge you this. They need to do that 30 days in advance. Otherwise, the increased fee that's built into the lease, for me, that's a material term that changes the arrangement. So it's better if the landlord is giving a 30-day notice that says this will be what we're doing going forward. And again, even if your lease expires right now, there's no opportunity for the landlord to go to court. So you don't have to leave the unit, but you will be responsible for rent at least the rate that was in your written contract.
Thank you. So there was also a comment, someone said their landlord has asked them to sign over their stimulus checks and then he will waive the late fee. Can a landlord require a tenant to turn over their stimulus checks?
So I don't think that any landlord or anyone in society right now needs to try to extort someone for additional money. It is reasonable to say, let's write an agreement that, your rent's not going to be due right now because you're out of work, but you're going to turn over, this amount of money that is your rent. But the landlord shouldn't be saying, you have to pay more than what is due. So if a family of 4 is going to receive $3,400 because they have 2 adults at $1,200 and 2 kids at $500, that they're going to receive, they shouldn't have to, sign over $3,500 when their rent's only $500 or $600 and they're only 1 month behind. The tenant should say, you know, I will give you the rent that is owed. If the landlord wants to include a bunch of fees for it being late, you should know that there is a lot of national and local media attention on this issue. And there are reporters that are contacting me every day asking to speak to tenants who are being taken advantage of. Now, the same goes for landlords that are being taken advantage of. If you have the ability to pay your rent, you should pay your rent. But if the landlord is saying, you know, you can only stay here if you pay your fees, that's just not true. I would tender the rent that is due and give a written notice that says, I am not paying this fee. It's related to COVID-19. You know, I'll see you in court and we can talk about this fee at that time. I guarantee the court is not going to have time to deal with landlords or tenants trying to take advantage of the other during this crisis. The court's going to be asked to do what is fair and will act accordingly, because fairness is kind of the baseline for landlord-tenant court.
Thank you. So I did get a question about the CARES Act, which prohibits certain landlords from charging fees for non-payment of rent. Alyssa from Homebase will be addressing that later. So I want to move on to a question we got about allowing access to the property. A tenant reported having a lease that he has to let people in for showings of the apartment, but he doesn't want people coming into his home during this time. You mentioned a landlord's right to access. What about the right of a landlord to show the property to potential future tenants?
Sure. So the law, again, whether or not you have this crisis that we're in, says that the landlord must give 24 hours notice, and that the tenant should allow access if it's reasonable, but doesn't have to allow access if it's not reasonable. And sickness is a reason why it's not reasonable to show the unit. And the truth is, right now, with up to 20% unemployment, this is the funny part. I don't know why people would want to evict their tenants. There's no tenants lining up to fill those units. Everyone's in the same boat. I can't imagine the landlord is going to be selling a property during this period because of social distancing rules and mandates. That's just not an essential thing. But if your landlord, you know, wants to show your unit and they're not doing it for the purpose of harassing you, and they're doing it for a legitimate business reason, and they have absolutely 0 units available to show prospective buyers, you know, I would certainly give them a written writing that says, I'm not allowing you in my unit, and these are, you know, the health reasons why. And if they show up, I think I would probably start open mouth coughing, just to scare them away. And there's nothing wrong with a little, you know, display of to remind them of why that's a terrible idea. If a landlord's doing it for the purpose of harassing you, that is unlawful, and you have the right to sue the landlord.
Thank you. So you've mentioned several times the importance of putting everything in writing, and you touched on text messages, kind of the pros and cons of that. But if I need to convey something to my landlord and I put it in a text message, will that still count as a writing? And is there anything I should do to make sure I have that if I have to go to court?
Sure. So yes, it's appropriate to use text messaging. However, there are just dangers to that. You could break your phone, lose your phone, drop in the toilet, etc. And it is difficult to print those text messages. So when you end up doing screen captures and then you print it, it's very hard to read that conversation on the other side. You definitely want to print the thing because the court is not going to handle your dirty phone. So it's essential that you print it, but I'm telling you from a practical standpoint, and having been in court so many times with this, it is really difficult to convey, you know, what happened when you're looking at these screen grabs that have, you know, part of one conversation on one page and part of it on another page. And so it's just not practical. So what I would do is do it in text messaging if you have to. take those screen grabs and email them to yourself so that you can access them later if you get a new phone. And then remember to print them. Not a bad idea to also follow it up with an actual, handwritten letter that you keep a copy of. If you follow it up with that, then you have multiple copies of this that you can show the court and show that you did what you needed to do to preserve your rights.
Thank you. So a lot of what we have talked about with terminations and evictions has focused around the issue of non-payment. Obviously, that is a primary concern right now. But what about if there is a threat to life or property or criminal activity, and so the lease is terminated for that? If a landlord files an eviction, will that case also not be heard until May 15th?
That is true. So that is a real problem, right? If there you have a for-cause reason for terminating this lease, that definitely puts landlords in a bad situation, and I understand that. However, the community spread of coronavirus is an overriding consideration. The safety of me and my family outweighs the noise disturbance of your tenant. And that's just what it comes down to. We don't have enough shelter space for homeless people. We're building more, but this is a bad idea to make people homeless right now. If, on the other hand, you have criminal activity and a dangerous situation, you need to call the police. In eviction court, even in the best of times, it takes a minimum of 7 days to get an eviction order for a bad tenant who is going around shooting the place up. Better to just call the police and then focus on the eviction while that person's in jail. Safety is paramount. Although, yeah, again, I understand that it's going to be inconvenient, but it is just, the whole world is inconvenient right now.
Thank you. So one of the things I did get asked, if a tenant does vacate the property, we understand that you can't be evicted right now. No eviction orders have been signed since March 16th. However, let's say a tenant does vacate the property, but leaves things behind. We had someone who wanted to know how long a landlord has to hold onto that personal property after a person leaves.
That's a great question, and it happens a lot. So if a tenant leaves a unit and leaves property behind, either they've abandoned the unit or they were judicially evicted, the landlord is required to save that property for 30 days and store it, and the tenant has that period of time to reclaim that property. But to do so, the tenant has to contact the landlord and pay what is owed to the landlord. And that could be a real barrier, since that's probably why you're not staying there anymore, is because you couldn't afford to pay. And you're going to need that money to go elsewhere. The most important thing to remember is if you're being removed from a unit, you need to take the most important stuff with you. The landlord also has the right to go through your unit, and anything that does not have ascertainable value, they can discard. So there's a lot of disagreement about what has ascertainable value. I assure you that a couch that I think is ugly and should be discarded has ascertainable value to somebody. And if a landlord is negligent in their determination on what should be saved or what should be thrown out, the landlord could be sued for damages. So it's best, if it's not perishable items, to just leave it for 30 days so the tenant has the right to reclaim that stuff. That said, there are certain items that the landlord shouldn't keep from tenants, and that includes medicine and clothing, baby items. There's actually a whole list of things where a landlord cannot have a lien, and those items the tenant should be able to get freely from the landlord. I know it's an inconvenience for the landlord, but medicine is one of those things where that the tenant's going to need, and hopefully they didn't leave it behind. But it's one of those things where communications is key.
Thank you, everyone that has asked a question. I will go ahead and answer. One question we did get was, what was the typical number of evictions that were filed in Tulsa prior to March 16th? As a general point, 14,174 evictions were filed in Tulsa County in 2019. So that just gives you a sense of how busy and full that Tulsa County docket is. Thank you, Eric, for your wonderful presentation, for answering all of the questions. The presentation will be made available as well as a recording of this. So next we will move on to Alyssa from the Tulsa Health Department, who will be discussing habitability with us.
All right, let me pull up my screen. All right, can everybody hear me? All right, we'll go ahead and get started. Thank you for participating in our online presentation today. During the COVID-19 response, THD is committed to our mission to improve health and well-being of all Tulsa County residents. We are seeing the importance of public health play out right before our eyes. So our community understands now more than ever how important it is to have safe and healthy home, how important it is to our security and mental health. In the last couple weeks, we have been confined to our homes in a way that none of us have ever experienced before. So normally, whenever I do my housing presentations, I talk about weather-related events because we're in Oklahoma, and that sets the tone so everyone can relate to living in a home without hot water, heat, or electricity. But now with the COVID-19, we have another layer of stress. And of course, THD is here to investigate complaints and require that property managers or landlords are repairing those housing violations. So my department, Environmental Health Services at the Tulsa Health Department, I want to point out that most owners in Tulsa are very good operators, and they try to do the right thing. When something breaks, they fix it. This presentation is really meant to educate tenants living in unsafe situations. So my department, Environmental Health Services, we inspect rental properties in Tulsa County. We do have the authority to require that landlords and apartment managers repair violations. The city of Tulsa and the county handle housing complaints differently. The city of Tulsa, we have Title 55 Property Maintenance Code, and outside of the city limits, we have to fall back on the Oklahoma Landlord Tenant Act. So whenever we get a housing complaint, if it's in the city, we're using the Title 55 that's available online at the City of Tulsa website. And then the Landlord Tenant Act is what I have to use in response to the county complaints, because there's no housing code. One thing that I want to stress to you is that the health department works with both tenants and owners to try to correct the violation or any issues without causing more stress. The health department does not remove people from their homes. If they are living in an unsafe situation, we're not there to put a 10-day timeline on it and kick them out of their home. We really just want the violation to be taken care of. And even if the tenants are not able to pay their rent, like what Eric was saying, that their housing situation cannot be unsafe. So here's a list of our Big 10 housing violations. So if a tenant is experiencing these, they can call the health department and submit a complaint. These are our most serious violations that definitely impact health. So no water or no hot water, surfacing sewage. This is one that if we received a complaint in our office, we respond to it immediately, and it has a correct by within 48 hours, or we can have the meter pulled. And inadequate heat, thank goodness we are not having to deal with extreme cold temperatures on top of COVID-19 and people being out of work. Your home, apartment or home, it required to have not only heat, but safe heat. So you cannot use a stove, whether it's gas or electric, to heat your space. Those ventless heaters that are just pumping out carbon monoxide, space heaters connected by extension cords, none of these are considered safe heat sources. Air conditioning, if your home was rented with air, it needs to be maintained. So if you have a central heat and air unit and the air goes out, the owner cannot replace it with one window unit. That is not the same. So we don't have a temperature requirement on air like we do heat. And then another really important one that we get calls on a lot is the fire protection. So smoke detectors are required and they need to be maintained. Windows need to be easily opened and no barriers for egress. So if there's an emergency, people can get out of the home. We do have other complaints that are important, but not like the Big Ten. So mold, we do not have any regulations in the state of Oklahoma for mold, but what we do is we try to address the plumbing or ventilation violation that is causing the mold issue, and then we educate the tenant and the owner about how to get rid of the mold, like whether it's a detergent in water solution or a mild bleach in water solution to clean up and then keep the area dry. Of course, homes are required to be rented pest-free. Bed bugs, we do have issues with bed bugs, and it's something that we see in apartments and duplexes is that bed bugs, they move from one unit to another. So we really try to educate the public on how to do their part to get rid of bed bugs. And we have all that information on our website. And then for nuisances, inside the city of Tulsa, the city limits, the Working in Neighborhoods Department is the one that work the high grass and weed complaints and the trash, junk, and debris complaints. But in the county, the Tulsa Health Department will do that. So if you wanted to submit a complaint to the city of Tulsa for a nuisance, you could always call 311 to get that addressed. So if you do have a complaint that you want to have investigated, you can either go to our website at tulsa-health.org and you can submit a complaint online. You can call our main number, the 582-WELL, or our direct line to our department is 595-4200. One thing is these complaints can be anonymous, and we don't tell whoever you call your complaint in on who it is. So no worries there. The complaint is assigned to the district environmental specialist, and when we call renters, we ask them first, have you talked to your owner? What does the owner say? Because they are required to let the owner know that they have an issue in their home before they, start calling the health department and complaining about. We need to give the owner a chance to repair it. So a lot of times we like to point out, let the owners know that we don't necessarily follow through with every single complaint that comes in our office. We'll educate the complainant to let them know that they have to let the owner know first and what the procedures are according to the Landlord-Tenant Act, and give the owner a chance to fix it. And then the owner does, and the owner might not even know that they contacted the health department to get that information. So normally whenever we get a complaint, we will go out to the home to inspect, and sometimes we find other serious violations like no smoke detectors during the process. But because of COVID-19, the inspection process has definitely changed. We'll still ask those questions to make sure that the tenant has notified the owner. We wait, let them know about the appropriate amount of time per the Landlord-Tenant Act. We might confirm with pictures if needed on what type of violation that they're experiencing then in the home. Definitely try to call the owner and manager to discuss the complaint and try to get it corrected. We definitely understand that there's two sides to every story, but at the end of the day, the health department, we really just want the violation to be taken care of. So especially on those big 10 housing violations, that we really are focused on getting those corrected. So whenever we do have a complaint and it's confirmed, of course, we would send out an order to repair or a notice of violation, depending on the type of violation and where it's located. We will send copies, certified mail to the owner and post it at the property. We can give copies to the tenants. The time frame for correcting a violation is generally 10 days. That's the minimum. Unless it's a sewage complaint and it's 48 hours. And the environmental specialists are very used to talking to the owners and coming up with some kind of a corrective timeline. We know that you cannot get all violations taken care of within 10 days, but we really want to be have that open communication with the owners so that we can get things taken care of. So we do have some corrective actions that we can take if owners are not responding. So again, with an order to vacate, this is for those most serious, the big 10 violations. So for example, no heat. If the owner has been notified that there's no heat and they did not get that corrected within 10 days, or make an attempt to contact the health department or the tenant to make those arrangements. We don't see any end in sight to the no heat issue. The THD can issue an order to vacate, and that gives the tenant the ability to make that decision. Again, the health department does not remove people from their homes, but it gives them that ability to make that decision and talk to their lawyer and figure out if that's the best option for them. We can issue warnings and citations. THD can issue, or we can condemn a property. And that doesn't mean that the health department or the city takes control of the property. Generally, we flag the meter, and it just means that no one can move into that home until those violations were taken care of. And that really protects future tenants and some of our bad players that we see in the Tulsa area for moving people into homes that have violations that future tenants might not realize until they're in there and it's too late. So now that we've talked about housing violations and the inspection process, I want to remind everyone where we started. Housing violations can cause serious health issues. In this time of safer at home and COVID-19 response, it's important to have a safe and healthy home. So there are lots of health issues that can be caused by hazards that we have in our home. And THD has a program that educates landlords and property managers and renters on safe and healthy homes. We can train employees, provide renter walkthrough inspections, and conduct courtesy inspections. This program is free, and you can get information about it on our website. We launched this program in 2019, and we've had a really good response with it so far, just trying to educate people on what safe and healthy homes look like. So here's an example of our renter walkthrough inspection, and these documents are available on our website, or of course, if you're signed up for the Safe and Healthy Homes program, then I can get you some copies as well. This tool is really helpful in opening up that communication between tenants and owners. And so the tenants learn what the owner's procedures are for putting in requests and getting things repaired, because things go wrong, right? Like your air goes out, or you have a plumbing backup and things need to be repaired. It doesn't mean the owner's doing anything wrong. It just means that we need to get the violation taken care of and move on. So we have these available as well. And then here is my contact information, our website. I have a full-length presentation on housing, our Housing 101 presentation that's available on my website. that you can review later. And then of course, this one will be posted later as well. And do I have any questions, Kristen?
What we're going to do, since we're running a little long, is we're going to go directly into Alyssa's presentation.
Okay.
But after Alyssa speaks, I have been getting questions for you, and I suspect I'll have questions for her as well. And we'll address all those questions there at the end.
All right, sounds good.
Great. So Alyssa, we'll hand it over to you.
Great. Can you hear me? I'm just going to start to share my screen just a second. Okay, I hope you all can see my slides. My name is Alyssa, and I'm from an organization called Homebase, and we're a nonprofit that works with communities around the country, providing technical assistance to help them prevent and end homelessness. And I am going to go through some of the tenant protections and funding resources that have come out in response to the COVID-19 pandemic for those people that may be facing evictions, are at risk of homelessness, and are homeless. In the interest of time, I'm going to run through these very quickly, just because I think we'll get through the eviction moratorium. We'll have all of the slides available, and we're available for questions after this as well. So as most of you know, on March 27th, Congress passed the Coronavirus Aid, Relief, and Economic Security Act, which is known as the CARES Act. And this includes $330 billion in new funding to address the needs of American people as we combat this pandemic. And this includes funding for affordable housing and homelessness assistance. There are two really main aspects of this that I wanted to talk about today. The first is the eviction moratorium for certain properties, which noted here is in effect for 120 days, and the additional funding to support persons at risk for experiencing homelessness. So I'll start with the eviction moratorium. This restricts people that hold mortgages for covered properties, and I'll go into that in the next slide, from filing new eviction actions for non-payment of rent, charging fees, penalties, or other charges to the tenants related to such non-payment of rent. And I know there was questions about this. So for any of these covered properties that I'll go over in the next slide, the landlord cannot charge fees for non-payment of rent. And after the moratorium expires, there still needs to be a 30 days notice given after the moratorium period. So the moratorium will be over on July 25th. So after that date, the landlord will still need to give 30 days notice of eviction. Here are a list of the properties that are covered by the CARES Act eviction moratorium. The way this statute is written, it covers properties that are covered under the VAWA, Violence Against Women Act. And this is not necessarily specifically properties that are related to housing people that are victims of domestic violence. This is really an easy, short way for Congress to include quite a few public housing options in this. So it's really a shorthand, and those first three rows are pretty much all of the different properties that are covered under this VAWA catch-all. There's also properties covered that are part of the Rural Housing Voucher Program, and then properties with federally backed mortgage loans. And the language here is pretty broad. It includes any loan made in whole or in part, or insured, guaranteed, supplemented, or assisted in any way by any officer or agency of the federal government. So this is very broad. I mean, I know there was a moratorium before the CARES Act was passed on the Fannie Mae and Freddie Mac loans. This seems to include additional loans, things through HUD, the VA, USDA, things like that, and any loan that is secured by the federal government. So it is important to note here that for renters, they might not really know whether the building they are in, the unit they are in, is secured by a federal loan. And so this is something that is going to be a little difficult. And so if anyone is being evicted during this time, any advocates, we would recommend really trying to push for the burden to fall on the landlord to demonstrate that their property is not subject to a federally backed loan, rather than having the burden as a tenant to prove that it is. So, you know, this could cause some difficulty, but hopefully with trying to shift that burden, that will make things easier. But, you know, as a tenant, you may not know whether the mortgage that your building is secured with is federally backed. Here we talk about what is not covered by the CARES Eviction Act. So any evictions that were filed before the moratorium took place on March 27th are not covered. Any that are filed after the moratorium sunsets, which is July 25th. And remember, I did note that if something is filed after the sunset date, it is still subject to a 30-day notice, but these are not covered. The non-covered tenancies, which are those tenants that are not in a property that I just discussed, those various programs, public housing, McKinney-Vento Act properties, and federally backed loans, and evictions based on another reason besides non-payment of rent. So this is something that kind of goes back to Eric's point. I mean, he made the point that a lot of evictions are now, or prior to this, were based on non-payment of rent. So we might see a little shift here, and landlords trying to evict people for other reasons. You know, as an advocate, it seems to make the most sense to really assert that this moratorium, the spirit of the moratorium, is to bar the filing of any eviction that's motivated, whether that's wholly or in part, to a tenant's non-payment of rent, whether or not that is the formal basis for the eviction. So that is something to kind of keep in mind. I mean, I think the spirit of this is to really make sure that people are not being evicted for non-payment of rent. So that covers the eviction moratorium. I'm just going to run through very quickly some of the other funding opportunities that are available. The Emergency Solutions Grant is additional funding that is coming to communities. You'll see here the amount that was distributed to Tulsa and Oklahoma. And I apologize, I'm going very fast, but we're basically at the time limit of the presentation. And as I said, these slides will all be available, so we are happy to answer questions. This is another opportunity for $1 billion being distributed nationwide for various support services and housing opportunities for people who are at risk or experiencing homelessness. These are some of the components that fall under this Emergency Solutions Grant, and HUD has loosened up some of the requirements to make this money easier to spend and address the needs of communities as they are working to react to the COVID-19 pandemic. And so they have made infectious disease preparedness part of as an eligible cost, and these are reimbursable back to costs that were incurred prior to March 27th when this was enacted, as long as they were being incurred as part of the reaction to the pandemic. Other CARES funding that is available to help people who are at risk of homelessness or experiencing homelessness, there's community development block grants, HOPA funding, and you'll see the amounts that were given to Tulsa. And I just want to note that this is just the first allocation coming out. This is kind of done in waves. The same for the ESG grants. There should be additional funding coming down eventually, but the first wave was $1 billion in ESG. So I'll go back to that slide. There is going to be $3 billion more distributed, so there should be more money coming into Tulsa and Oklahoma and potentially Tulsa County as well. And then the HOPWA, the same for the community development block grants and the HOPWA funds. There is additional funding coming. There's also the coronavirus relief fund, and that is kind of more a broad funding stream that will have a lot of demands on it, but there could be some potential to use money for eviction prevention, helping rehouse people, things like that. And then of course the individual payments that most people are eligible for, up to $1,200. And then I'm going to quickly note that HUD has put out a few waivers to help people spend down the various grant money to help address this pandemic, including the way that COC, ESG, and HOPA funds are spent. We have a great summary of those waivers, and there's a link there. And again, we'll send out these slides to everybody. So we welcome you to look at that and to help understand those waivers if you run one of these programs and need to review those and how you can, how these waivers would apply to your program. And finally, we have a website on Homebase, on our website that is directly about COVID-19 response, with a lot of resources that we encourage you to look at. And here is also an email address that you can send your additional questions to. And again, I apologize for running through that really quickly, but I want to respect your time. And of course, we're happy to answer questions as they come in.
Thank you so much, Alyssa. Now, we have reached the end of our time. However, we are going to take questions for both Kendra and Alyssa. If you need to leave because you have another commitment, then the recording is going to be made available. All the slides are going to be made available. Alyssa, I wanted to touch on a question that we got asked. Eric talked a lot about late fees. Now, if a tenant is being asked by their landlord to pay late fees and there's a provision in their contract that says they're responsible for late fees, how does the CARES Act affect them?
Well, they would need to be a part of one of the covered properties. So that is something that I think would need to be determined. I mean, it will be hard for tenants to figure that out, unfortunately, if they are just part of those that last two categories of buildings that are covered by federally backed loans. But this, even if it's in the lease agreement, my understanding is that there is still a moratorium on that. So there should not be any late fees assessed.
And I know you've already said it will be difficult to find out. Are there resources available right now to help tenants find out if it's federally backed, or do we hope that might become something in the future?
Well, I think part of the problem is that there might be ways to research this at the county level, you know, as most of these things are reported there, but a lot of those offices are closed. So I'm not quite sure locally what is available at the county and whether the people are able to access that information. I'm not quite sure if there's going to be a database or something. I can certainly look into that. There might be some options, but I think typically you would try to find that out at the county level. And so that might be a little difficult in these times when, you know, either the people are remote working or government offices are closed.
Thank you. Kendra, we have a few questions for you. One of the big questions was, with the Tulsa Health Department investigating complaints, do they investigate complaints for all types of residential properties, or is it limited to public housing versus private housing?
No, it's all types of properties. So except you cannot call in I guess you could call in a complaint on your neighbor. Like you could say, my neighbor's house is gross, and I cannot go busting into your neighbor's house and then make that decision that their house is gross and make them fix it. So this is a landlord-tenant type situation, both public housing and private houses, apartments. Yes, the tenant is inviting me into their home to investigate a complaint.
Thank you. Can a landlord charge the tenant for repairs? And for example, if the landlord needs to spray for bed bugs, can they pass that cost on to the tenant?
So bed bugs, it gets really kind of tricky. So we have to, of course, we refer back to the lease. A lot of landlords and property managers, they have those procedures laid out, especially in an apartment complex, because it might be a common problem that they have to deal with. Generally, the home is rented pest-free, and then after that, it is the tenant's responsibility to maintain that property. So whether it's roaches or mice or bed bugs, it's thought that they were the cause of it. So we have to handle those on a case-by-case basis, depending on the timeframes of when they moved in, because sometimes pest could be there but not show that it's a problem until a month into someone living there. So we just have to talk to the tenants and talk to the owners and try to figure out the best course of action.
Thank you very much. We had a question about this. If there's a violation pending that the Tulsa Health Department is investigating, can a landlord continue to collect rent from the tenant?
If
That may also be a question for Eric.
If there's a violation that the health department is investigating, can the landlord continue to collect rent? So, okay, so I'm trying to wrap my mind around that question because it feels the opposite for me, but we advise the tenants to always continue to pay their rent. So even if they're living in a home with no heat and it's the first of the month, they are due that rent, whether or not they have this violation that they're complaining about. They always have to pay the rent. That agreement with the lease is a priority. But I mean, of course, I would always refer to Eric whenever I have special legal questions, because I'm not really sure all the ins and outs of the Landlord-Tenant Act.
Eric, if you're still there with us, can a landlord collect rent while the Tulsa Health Department is investigating a violation?
Sure. So the tenant never gets to stop paying rent unless the tenant moves. There are a very few limited circumstances where the tenant can leave the unit and not pay rent if at the very beginning of the tenancy, the landlord fails to deliver possession of the unit, including in a safe and habitable manner, then rent abates. But otherwise, once the tenant's in there, they owe rent unless they decide to move out because of the problem, and at which point they no longer owe rent.
Thank you. So we're getting a couple questions about resources for tenants as well as resources for landlords. I do want to note that, as Alyssa touched on, new funding is being made available to states and local governments through the ESG funds. There's also been a loosening of restrictions on funds that states and local governments already have. That's changing rapidly. That is changing not just day to day, but it seems like hour by hour. So I would encourage anyone, if you have a question about rental assistance resources, legal resources, to call 211. They are continuing to be updated every time something is available, and we're always providing them with more information. As I said, that's going to change constantly. If you do have, in terms of rental assistance for tenants, I know that's something that both tenants and landlords are really interested in. You can search the 211 website. It will identify those. We've also posted information on the Away Home for Tulsa website, and that website contains a notice to both tenants and one to landlords that lists rental assistance resources that you can access and contact directly. All right. And this, I think we have one last question. And I think this is for Eric as well. You touched on this briefly. If there is an urgent maintenance request, so let's say there has been a Tulsa Health Department inspection, a violation's been found, and it needs to be addressed immediately. What are the guidelines for the maintenance person or the landlord entering the property to address that immediate and urgent need?
Okay, so first, if you have an immediate and urgent need, you probably need to have contacted your landlord before the health department, and if the health department had to be involved to get the landlord to act, that's pretty terrible. I mean, I know it happens. You need to remember that you make your request in writing. If it's an emergency, you can call them on the phone. But you need to follow it up with writing or you won't have any rights. Generally, if it's an essential service such as water, electric, gas, heat, plumbing issues, the landlord's required to fix that as soon as the circumstances dictate. Unfortunately, if the landlord doesn't fix it, the tenant's right is to move out and stop paying rent, and then can sue the landlord for damages and breach of contract. During COVID-19, what you need to consider is your family's safety. So if you have people in the unit that are, sick, they need to be at least isolated in a room and give that maintenance person an opportunity to come in and do their job, make some soap available for them to do their hand washing for 20 seconds at the sink, have sanitizer available or whatever else, and go through and do all of those things that, Mayor Bynum and President and the governor have reminded us we need to continually do, and the health department is reminding us that we need to do to stay safe. If you have an urgent need, you need to let them in and use good sense.
Great. Thank you, everyone, for participating. I know we ran a little long, so I appreciate your patience and your cooperation. We will be making a recording of this available online. We will also make the slides and the presentations available. If you have further questions, if it's a question about resources, I again encourage you to reach out to 211. They are a fantastic way to connect with resources that will meet your specific needs. Thank you again to all of our presenters. Your expertise has been invaluable. Thank you very much, everyone, and have a nice day.